When youngsters playing together start squabbling, responsible adults can impose a timeout or simply separate them. When adults running a small business start squabbling, it can get more complicated. But as demonstrated in Balvik versus Sylvester, courts still have plenty of tools to address the situation. Elmer Balvik and Thomas Sylvester formed Weldon Electric, a partnership, as an electrical contracting business. Balvik quit his prior job and contributed $10,000 in cash and assets to the business. Sylvester contributed $25,000. Despite their unequal contributions, both partners had an equal vote in the business's management. 5 years later, they incorporated. In line with their original contributions, Sylvester received 70% of the stock and Balvik received 30%. The board of directors consisted of both men and their wives. The board elected Sylvester president and Balvik vice president. Balvik also worked as an employee. Problems arose a year later due to differing business philosophies. Eventually, Sylvester fired Balvik as an employee. Balvik didn't receive a salary, dividends, or any monies from Weldon thereafter. Balvik eventually found work elsewhere. Balvik sued, seeking Weldon's dissolution or to be paid the true value for his stock. A few months later, Weldon held its annual shareholders meeting. Sylvester voted his 70% of the shares to reduce the number of directors from 4 to 3 and to reduce the directors needed for a quorum to 2. Sylvester and his wife then voted themselves and Peter Sylvester onto the board. Then they elected Peter the new vice president, removing Balvik as a director and officer. The trial court ruled that by firing Balvik from his employment, removing Balvik and his wife as directors, and denying Balvik any benefit from his ownership stake in Weldon, Sylvester had engaged in oppressive conduct. The court ordered Weldon's dissolution. Sylvester appealed to the North Dakota Supreme Court.